Hello, my name is Mark Nacol. In general civil litigation, the process commences with the filing of a complaint or a petition in state or federal court. The defendant has an opportunity to answer that complaint, and then the fun begins. The discovery process is a process which permits you to ask questions of the other side as to any information that tends to lead to relevant information. That's pretty liberal interpretation of what can be, will be ordered provided. Documents must be produced, inspections can be made to the subject matter of the lawsuit. If it's a bad roof, you get your expert going to roof. If it's a broken foundation, you can do that. If it is an artificial intelligence, you can get your scientists and physicists to verify the uniqueness of the intelligence. It is a process of gathering facts. Once this process is concluded, you go into the deposition stage. That's where your attorney will ask questions of your opponent. And it's pretty wide in scope. And it gives an opportunity for your attorney to make your case in sworn testimony. Other witnesses and you will also be deposed to try to ferret out irrelevant issues, so at the time of trial, the core issues, the important things, are the things that are truly addressed. Following depositions, sometimes settlement discussions can commence. If they fail at this juncture, the next phase is to have mediation. Mediation is an alternative form of resolution, far less expensive than a jury trial. It's not arbitration. The mediator can't tell you what to decide, but you can be forced to stay in there for 10 hours, saying no the whole time. Mediations are very, very successful generally. 80, 90% settle and save everybody a lot of money except the lawyer, because the case is over. If mediation fails, the next step is trial on the merits. You prepare your case, you give opening arguments, you voir dire the jury prior to the opening to make sure that you have a fair jury that's not biased in some way against your claim. Following voir dire and opening arguments, you present your case. And ladies and gentlemen, I'll tell you, I've tried a lot of jury trials. I've seen fancy exhibits. I've seen techno-idiots do all kinds of things. But in general, sincerity and the broadness of your shoulders will take the day. If the jury believes you, if the jury believes you're telling the truth and your claims have merit, it's very difficult to move them. You have a very good chance of being successful. Truth is the overwhelming decider of cases. You may have heard of runaway verdicts and the McDonald's this and the that. Juries are smart. They're not stupid. And they generally come to the appropriate conclusion. And that conclusion inevitably is based on the credibility, the broadness of your shoulders, and the presentation of your case. Following presentation of your case and the defendant's presentation of the case, argument will occur. That's a chance for the lawyers to speak directly to the jury and summarize the evidence. I'm sure some cases are won in the closing arguments. I've been told I've won cases in the closing arguments. I don't believe it. I think with a closing argument and $1.25, you can buy a cup of coffee. Cases are won in the preparation, in the exhibits, and the witness preparation. Now, some cases have simply poor facts, and you can't win no matter how honest you are. But in the majority of the cases, they're won or lost before the jury's ever called in. Following argument, the judge instructs the jury on the law. And the jury is told, apply the facts as you find them to the law I'm giving you. And a series of questions are given to the jury, and they answer the questions. After the conclusion of arguments, the judge will enter judgment on the verdict, if that's appropriate, and apply laws to the verdict of the jury and enter a judgment. And then following that, the appellate process, if necessary, proceeds to review the decisions of the judge and the jury, up to the Court of Appeals and finally to the Supreme Court. It's rare that a case goes that far, extremely rare. I believe cases are determined in the first 5 months of preparation. If the proper preparations is done, and if your claim is valid, if it is a rightful claim, frequently justice will fall like a ripe plum.